Good morning. Welcome to an oral argument session of the 5th District Court of Appeal. My name is Jay Cohen, and I'm honored to be joined today by Judge Dan Traver and Judge Letty Marquez. Remember that this is recorded on YouTube, and thousands of people are no doubt going to be watching this. The case number is 19-2300, Ghulam et al. Versus the estate of Anwar Ali Mohammed Taqi Rashid. Both sides will be entitled up to 20 minutes each for their arguments. I have a 5-minute default for rebuttal, but if you'd like something different than that, all you have to do is let me know, and I'll be glad to give you, whatever amount of time that you want. If you could keep your microphones on mute until such time as you're actually speaking, that probably would be helpful and avoid interrupting the other side. So that said, Mr. Brownlee, you may proceed, sir.
All right, good morning, Your Honors. May it please the court. My name is Mike Brownlee. I'm here on behalf of the appellant, who are the 7 siblings of the decedent, Mr. Rashid. And I'm okay with 5 minutes for rebuttal, Judge Cohen.
All right, thank you, sir.
Mr. Brownlee, good morning. Before you get into the substance of the case, will you address jurisdiction for me? If I have a couple of questions about it. One, I think that you would have to concede that below this, and I know that you weren't the lawyer below, that this wasn't recognized, captioned, served, identified in any way as an adversary proceeding. So I wonder, having read your supplemental brief and having read Ms. Dixon's, is your argument solely 5.025A says an adversary proceeding falls under these enumerated categories, and as a matter of course, rules of civil procedure kick in, even if we don't caption them? Or is your argument predicated in any way on Rule 5.020A, which basically says we look past any pleading deficiencies as they relate to substantial rights? Does that question make sense?
Yes, the latter. I think yes. Any pleading deficiency shouldn't be, wielded against any party to affect their substantial rights, certainly, and also under 5.025A. There are 2 categories that are listed as specific adversary proceedings, and this case falls squarely within 2 of those categories. And one is a proceeding to remove a personal representative, and the second one is a proceeding to determine beneficiaries. To ascertain whether or not this was a proceeding to remove a personal representative, the title of the petition was Petition to Revoke Letters of Administration, appointing Ms. Rashid as personal representative of the estate, and to cancel the order appointing Ms. Rashid as personal representative. So, and of course the title is not dispositive, but then you go to the wherefore clause, and it reads as follows: petitioners request that the court enter an order revoking the letters of administration and the order appointing personal representative in these proceedings.
So you read 5.020A, substantial rights, as commensurate with triggering appellate court jurisdiction?
No, I think that the failure to caption it properly, and I guess to the extent this record reveals whether or not the formal notice provisions were complied with, that those technical deficiencies should not preclude what the rule is otherwise clear on, which is that certain types of proceedings are adversary as a matter of course. Does that answer your question?
It does, thank you.
Okay. And
is it your position 5.025A is self-executing?
It is, Judge Cohen. Yeah, I think so. I mean, it says unless otherwise ordered by the court. You know, I don't know how else to. I think that's what the language of the rule is conveying. Yes.
Okay. All right. Go ahead.
And just quickly, the second category this case falls into is it's a proceeding to determine beneficiaries. I mean, I don't know how you can read the record below and the briefs on appeal and, you know, come away with any conclusion other than this was a proceeding to determine who the beneficiaries, the rightful beneficiaries of Mr. Rashid's estate were.
Okay, let's go ahead and get then to the substance. What I'm trying to get my arms around, Mr. Bromley, is how we determine on this record what Sharia law says about foreign properties that weren't listed in the UAE probate proceeding. It's one thing to say that the law of the foreign domicile, I don't know why I struggle with that phrase, applies. But it's another thing to know, you know, what that law is.
Right. Well, here we have the luxury of a certification from the UAE probate court saying, I mean, they were asked.
But you see that you know they had some you've got a declaration, they've got opinions, there's all kinds of conflicting information about what the law was that was provided to the trial court. Do you agree?
I think conflicting is not a fair characterization. They have a couple of emails from their own attorneys responding to what I would describe as loaded questions about, you know, how the law should be applied. There's no citations to any UAE law or anything. On the other side of the ledger, we have a certification from the court declaring declaring specifically that UAE law does not preclude application of UAE inheritance laws. And this specific schedule of distribution outside the UAE and to an asset that's outside the UAE.
This trial judge, you know, bent over backwards and gave you all the opportunity to go back in to the probate court in the UAE and have them resolve this issue and distribute this property, and the UAE probate court declined to do so.
Yeah, Your Honor, I think that was the wrong inquiry. The question was never should have been whether the asset was probated in the UAE. That's a jurisdictional concern. That this is an ancillary proceeding that was initiated by Ms. Rashid. So, I mean, otherwise, if it was an ancillary proceeding, then there'd be no basis for jurisdiction at all. So, you know, you have this happens. You see it in the cases where you've got two different jurisdictions probating the assets of the decedent at the same time. And, you know, all that mattered at this point was, does UAE law, as the Ms. Rashid argued below, does any portion of UAE law preclude application of UAE law outside the United States? Because Florida law says that's what you have to look to very clearly. So the starting point, the finish point, as our side argued the whole, you know, throughout the proceedings below, should have been, okay, Florida law says we have to look at the law of the UAE. It's not a question of jurisdiction and whether the UAE court probated this asset. That should never have been part of the inquiry. The question is, does UAE law preclude application of this decree of distribution to outside the UAE to an asset located outside the UAE? And we went back and got a certification from the UAE court, which I have to think trumps, you know, I mean, if you have a court of the same jurisdiction that's issued all of these other orders that we have in the record saying this is the state of UAE law versus, you know, a couple of, you know, snippets of without any citation to authority from the other side's attorneys. You know, I think if the court says this is what the law is, that's what the law is. I mean, that's part of the comedy argument, is that you've got to give deference to what another court is doing and what they say about their own laws. So I acknowledge that the trial court tried to give the parties, leeway to get this figured out, but it was just they were going down the wrong path the entire time. That 731.106 is crystal clear. What it says: if someone dies outside of the United States and they have intangible personal property in the United States, it's the law of the decedent's domicile that applies. So, and we know now in the record, we have, in my opinion, a conclusive statement from the UAE court saying there's no problem under UAE law with applying this decree of distribution outside the UAE. I really think it's that simple. I don't have much else to add unless the court has any additional questions.
All right. If nothing further, then we'll just let you go ahead and reserve the remainder of your time for rebuttal.
Thank you.
All right. Counsel, Ms. Dixon.
Please support Jennifer Dixon on behalf of the appellee. You guys can be okay, I'm sorry.
It's a little difficult to hear you. Can you increase your volume by chance?
I think I can. Is that better?
That is better.
Okay. As outlined in our supplemental brief on jurisdiction, we strongly feel that this court should dismiss the appeal because the notice of appeal was untimely filed.
So let me just examine that a little bit. You strongly, you don't just feel it, you strongly feel it. And you felt it so strongly that you filed a motion to dismiss?
We did not, Your Honor. All credit goes.
So you feel it strongly enough to file a motion to dismiss, and you didn't feel it strongly enough to brief the issue, right?
Your Honor, because the court identified the lack of jurisdiction. Counsel,
you had an epiphany.
We had an epiphany, thanks to the wise, honorable court. But it is a valid issue.
Why isn't 5.025A self-executing?
It is not, because 5.025D says that in order to proceed under the rules of Florida civil procedure, that formal notice must be served. Formal notice was not served in this case. The record does not demonstrate that. The record post petition does not recognize that, because formal notice would require that the PR would have filed an answer, affirmative defenses.
How do you reconcile that argument with the host of cases under 5.020A that basically say, and I won't paraphrase, it says no defect of form impairs substantial rights. How do you reconcile those two arguments?
Well, Your Honor, form might speak to the caption in the petition, but form does not speak to formal notice. Formal notice is a due process issue, and I don't think that can be waived by rule.
Wouldn't it be incumbent upon your client to raise below, as opposed to arguing that it's barred to jurisdiction on appeal?
Well, we didn't hear the adversary proceeding moniker until we got to appeal. And there are cases that say a case may not be treated as an adversary proceeding for the first time on appeal. I think
there's one case that says that, and that's a 5.025B case where it didn't fall into one of the enumerated categories. I'm curious, because I've looked, was there anything that you could find that suggested that same type of law that's in Beeman, is the name of the case, would apply to an enumerated case under 5.025A?
Well, I think 5.025D applies to cases under A and B. So I do think that the prerequisite to service and proceeding under the rules of civil procedure do require that formal notice. But
that's not exactly my question, though, because I understand if you're making a plain language argument based on D, we can go down a different path on it. My question is, were you able to find anything that found that law that was cited in Beeman and applied it to an enumerated case under 5.025A?
I did not, Your Honor. And to be frank, I didn't need to, because if you look at the substance of the petition, It is clear that this petition was not a proceeding to remove a personal representative.
I don't understand how you can possibly say that. Let me make sure. Did I unmute? What is the practical effect of revoking letters of administration and getting an order that cancels the appointment of a personal representative? What is the practical effect of that?
The practical effect is really set forth in their demand for relief. What they asked for was revocation of the letters of administration. What they did not ask for was removal of the personal representative under Chapter 7.3, which provides specific grounds on which a personal representative can be removed for cause. None of those causes.
We're talking jurisdiction here. We're not talking whether they win or lose. All we're talking is, an allegation for jurisdictional purposes. And if you revoke letters of administration, you are no longer a personal representative.
Agreed, Your Honor. But what I would posit is that 5.025A is referring to a specific proceeding under the probate code. And this petition did not meet that criteria. Similarly, it is not asking the court to determine any beneficiaries. They knew who they wanted to be the beneficiaries. They weren't asking for the court to determine that. They were asking for revocation of probate in Florida entirely. They were not asking for a new.
But my struggle with that is that you might be correct substantively, but in terms of whether it is a specific adversary proceeding under 025A, it seems to me that by the plain language of that rule, it is.
Well, again, Your Honor, there's no indication in the record that the court conducted this proceeding as an adversary proceeding. There are no citations. The word adversary isn't even in the record. There are no citations to Florida Rules of Civil Procedure anywhere except in the motion for rehearing, which was untimely filed. So our argument is simply that the formal notice requirement was not met. The record does not indicate that it was an adversary proceeding. And on its face, the petition does not meet the criteria of those specific enumerated cases that are specific adversary proceedings under the rule. But even
let's go to the substantive arguments then.
Yes, Your Honor. So in the petition, the appellants advanced really two theories in support of their petition to revoke the letters of administration. First, they argued that the decedent's interest in Rashid properties was not subject to probate in Florida at all because the property was governed by the UAE probate proceeding. Secondarily, they asserted that Section 731-106 required the personal representative to distribute the decedent's interest in the LLC to the same persons entitled to receive it under the laws of the UAE. The first theory failed because the documents produced by the UAE court showed that the Florida asset wasn't included in the probate and was not distributed as a result of that proceeding. So the circuit court gave the appellants the opportunity to provide something from the UAE to show that it had taken jurisdiction, but appellants just failed to make that showing. So the issue for this court is really whether the circuit court did or did not apply Section 731-106. Application of the statute requires that the court direct the PR to distribute those assets to the beneficiaries under the law of the decedent's domicile. Incidentally, the petition didn't ask for that relief. It asked for revocation of the letters of administration and the companion order appointing Mrs. Rashid as the PR. If appellants wanted to invoke 731-106, they really didn't ask for the right relief. But even if they did, they didn't meet their burden of demonstrating how the law of the UAE, which is essentially codified Sharia law, would have distributed the decedent's asset differently. On appeal, the appellants claimed that the court didn't apply Section 731-106 at all. And we disagree. We think the order clearly demonstrates that the trial court considered how the law of the decedent's domicile applied. But as Mrs. Rashid demonstrated, UAE law doesn't govern assets outside of the UAE. Also, UAE law doesn't prohibit foreign assets from being
Right.
devised in accordance with the foreign jurisdiction.
All right, so you're suggesting that in your view, the declaration does not address the issue of whether UAE law applies to, or the distribution scheme applies to property outside of the UAE.
I'm not sure I understand that question, Your Honor.
Well, their argument is that the declaration resolves that issue and sets forth what UAE law is in terms of the distribution of this asset. And
Well,
you're suggesting that it does not. So I want you to amplify upon that.
absolutely, Your Honor. The court, the certification, first of all, states on its face, it's not a judgment. It is a certification. And in one of the memoranda presented by Mrs. Rashid, the attorney explained the procedure for coming up with these certifications. The certifications, it says at page 62 of the record, the guidelines surrounding how heirs' portions are calculated are complex. And in each case, a Sharia scholar is appointed to decide how the estate is distributed. This is important because the certification does not cite to any law. There is no code in the broadly cited UAE federal law number 28 of 2005 on personal status, which has 365 articles. It's like citing to all of the Florida statutes at once. They did not.
Would it make any difference to your argument if you knew that Judge Traver is an expert in Sharia law?
I would love to be edified further on this. It's been a stunning.
Well, I didn't say it was. I just asked whether it would impact your argument.
I would appreciate the chance to confer later. But the point is, there's no specific code that was cited. And I think that as the appellants and as the petitioners below, it's their burden to tell us what law is the PR supposed to apply. They haven't pointed to a law. They pointed to a decree, a certification that's not even a judgment. And so basically they're asking the court for comity principles to apply. But comity principles only apply to foreign decrees. They don't apply to certifications from the court. And they don't apply if the substance of the order or decree violates Florida public policy. And I think in this case, Florida public policy is very clear. There is a strong public policy in favor of protecting surviving spouses. And in this case, the surviving spouse is given a minority share of her husband's interest. And further, it violates the Florida Constitution in that it treats male and females differently solely based on their gender. So I think if the court were inclined to apply comity principles based solely on the certification, which does not seem to cite to any specific code or law in the UAE, that the court would have to decline to afford comity to this.
Right. So let me see if I understand that argument. Assuming hypothetically that we had a clear record that showed under Sharia law that 75-25% distribution is the law that would and should be applied. Are you suggesting that we do not apply that law because it offends our constitutional provisions?
No, that is not my suggestion, Your Honor. If there were a law that said intestate estates are divided similar to Florida Statute 732-102, which says 100% to the surviving spouse, if we had that law in the UAE, I think 731-106 would require the court to compel compliance with that law. This is different. They're not asking us to apply a specific intestacy law in the UAE. They're asking us to.
My question though is let's assume hypothetically that they had a specific law of intestate succession and that it mirrored what the declaration says, which is a 75-25 split. The brothers get 75%, the wife gets the 25%. Is your argument that we would not enforce that because it's violative of Florida policy?
No, Your Honor, I don't think that 731-106 would allow the court to decline to enforce that law under 731-106. I think where public policy comes in is when we're affording comity to a foreign decree, which is what they've asked for here, because there is no law. And actually, the state of the law in the UAE allows the foreign jurisdiction to allow its own law to devise the foreign estate or the foreign asset. So 731-106 has been applied by the probate court below. They ordered the PR to distribute the estate in accordance with Florida statute, which is completely allowable under UAE law.
Yeah. Do you agree that if it were real property, that Florida law would require Florida law be applied?
Yes, there was no dispute below that this is
Right.
personal property, and that's the reason why we're here.
Okay.
In any event, it's Mrs. Rashid's position that the probate court did apply 731-106, and it did so appropriately because the law of the decedent's domicile permits distribution of a Florida asset in accordance with Florida law. So there was no error below in the trial court applying 731-106 as it did. It was the appellant's burden to demonstrate harmful reversible error, and it didn't do so. Based on the record before it, the probate court acted in conformity with UAE law and Florida law. So in conclusion, this appeal turns on whether appellants met their burden of demonstrating that the law in the decedent's domicile compelled a different result than that reached by the probate court. And based on the appellant's failure to cite any actual law in the UAE, any code, any statute, it's apparent that that burden wasn't met, and the probate court's order must be affirmed. Thank you.
Sorry. Thank you, Ms. Dixon. All right, Mr. Brownlee, you've got a little over 10 minutes. There's no penalty if you don't use it all.
Okay. I'm just going to defer to Judge Traver on his expertise of Sharia law and just
As we all do.
right. Your Honors, I want to make sure one thing is really clear. We've got two certificates. We have two decrees from the UAE court that are important here. We've got the original one that sets out the schedule of distribution. And then we have another one that we went and got later in the proceedings in response to the trial court's inquiries. It's at record sites page 91. And it says there, and it's referring to the Seminole County probate proceeding. It's acknowledging that there's an inquiry from that court. And it says there's nothing to prevent the implementation nor the division of the deceased legacy outside the UAE according to the details of the decree of distribution. So I don't understand where the dispute is on what the state of UAE law is. We have the court that both parties have been going to figure out the state of what's what procedurally with the UAE probate proceeding and substantively to figure out what the law is. To me, that should be viewed as dispositive. And all the sort of pot shots that we're hearing on appeal about, this wasn't really an order or a judgment, that wasn't ever argued below. There was no dispute. Both sides were using these same certificates throughout the proceedings below, and there's no argument that they're not valid, they're not representative of what a UAE court is saying about UAE law.
So if I can understand your argument on appeal correctly, you're acknowledging that the initial certification wasn't clear, but then when Judge Dickey basically said you've got 30 days to go back to Sharjah to get an answer on this, you're arguing that that second certification is what causes your client to prevail on appeal. Correct.
The first certification would just establish the distribution of assets under UAE inheritance law and says this is the percentage attributable to these parties who are the beneficiaries under UAE law. The second one answered the only question that mattered, which was does anything about UAE law prevent the implementation, just like the certificate says, prevent the implementation of that distribution schedule outside the UAE where an asset's located outside the UAE? And the
Does anything
UAE court said
in the
no.
record, and I think the answer is no, but does anything in the record account for why the language in that second certification was so imprecise? In other words, if y'all were sent back to Sharjah to answer one question, why wasn't that question more directly answered?
Well, I mean, Judge Traver, I think it was, I mean, given the language barrier and, things that are lost in translation, I suppose, and we're running a little bit of a hurry up offense because we're under a 30-day restriction by the trial court to get, well, I guess it was for a different inquiry, but I think the certification is as clear as it needs to be on the only question that matters. I mean, Florida law 731.106 says, under the circumstances we have in this case, you have to apply the law of the decedent's domicile. So, okay, so now we have to go back to the UAE. What does UAE law say? We have a certification from the court saying there's nothing in UAE law that prevents this schedule of distribution from being applied elsewhere to an asset located outside the UAE, which is flatly contradicts the appellee's position below and on appeal. I think the record is as clear as can be that that's the state of UAE law. And especially considering the countervailing evidence adduced by the other side, which was, like I said, it's a couple of emails going back and forth from Ms. Rashid's own attorneys. And they do not cite any UAE law either. So I think the record clearly establishes that there was no problem under UAE law with applying that schedule of distribution outside the UAE in this case. And that's what Florida law compels. And the statute says that's what we have to do. So, and the trial courts, was preoccupied with this idea that there can only be jurisdiction in one or the other. And, from a convenience standpoint, that might be true, but that's not correct from a procedural standpoint. I mean, you can have parallel proceedings going on at the same time. There are cases that talk about it. A few other just, I guess, minor points in response to Ms. Dixon. One reason, and this is speculation because it's not borne out in the record, but it's worth noting, Ms. Rashid filed her proceeding in Seminole County before the UAE probate proceeding was concluded. So, in her petition for administration, she swears that she knows of no other proceeding that's ongoing at the time that she filed hers, even though she knows full well she was participating in the UAE probate proceeding. So I don't know, but one reason that the UAE court may have been hesitant to bring this Florida asset into the probate proceeding was because there had already been one opened in Florida, and that happened before the probate proceeding was concluded in the UAE.
But that, as you said, that's completely, there's no record.
I'm just trying to explain why the UAE court may have been reticent to do what I think it would have probably viewed as stepping on the Seminole County courts.
And we could speculate why the Florida property wasn't included in the UAE probate as well, couldn't we?
Yeah. Okay, and I think Ms. Dixon said at one point that it was important whether UAE law allows Florida law to apply, and that's not the issue. The issue is Florida law says we have to look to the law of the decedent's domicile. We have a certification from the UAE court saying what the law is, and that should have been the end of the inquiry. I think it's that simple. And unless the court has any other questions, I'll reserve my time for my next oral argument.
Okay. All right, well, thank you both for your oral arguments, and you stay safe. Have